So guys, welcome once again to another episode of Scott Talks Law. So in this episode, we'll be talking about cohabitation under presumption of marriage. So cohabitation arises in situations whereby a man and a woman comes up and they claim to be or they regard themselves to husbands and wives, though there is no validity of that union, or there's nothing to show that indeed there is that marriage relationship. There was no marriage ceremony that was conducted, either religious ceremony, either civil or customary ceremony, and this union cannot be recognized in any aspect. It cannot fall under customary law. It cannot fall under. It cannot be recognized as a civil marriage. Neither can it be recognized as a religious marriage under Hindu, Islamic, Christianic, or any other religious system. So the family law is kind of trying to integrate within its system this kind of this kind of union, or this kind of people who like they are coming up and just claiming that they have been together, even though there's no validity or there's no formal or valid recognition of that marriage. So they say that so they have arisen those issues and complaints in regards to this union, and the people are claiming that is it truly a valid marriage even if it's not recognized within our system of marriage. And then the court has adopted this guideline that it's just a presumption of marriage, and they are saying that this presumption is a rebuttable presumption, such that he who alleges must prove. He who alleges that exists that presumption of marriage or cohabitation must come up and prove that truly there exists that marriage. And he who alleges that it's not a valid marriage, then he also must come up and prove or show that it is not a valid marriage. So the court has come up with those guidelines. So also Section 119 of the Evidence Act has kind of provided like the guidelines to that presumption, and it has said that any issue that arises during that substance of marriage, the court should presume that that marriage actually existed. And Section 119 of the Evidence Act says that the court may presume the existence of any fact which it thinks it's likely to have happened in regards to being the common cause of being as a result of common cause or human conduct or public or private business in the relationship to the fact of the particular case. So the court may presume, it's not automatic, the court may presume that anything might have happened during that substance of marriage. So so it's just a presumption, and this presumption they will be deemed to be a marriage even if they have not undergone any formal marriage ceremony. So family law is trying to incorporate certain situations which do not fall within the formal marriage threshold. So this presumption has been applied in Kenyan situations in regards to the Kenyan courts to have cited that this presumption existed under common law heritage as a presumption of marriage. So the Kenyan courts are claiming that the presumption just existed before, and because we apply common law in some certain situations, this presumption existed actually in the common law, and it used to be regarded as a presumption of marriage. So this cohabitation is like it's something like a presumption of marriage, where these people are just presumed to have been in a marriage relationship. So there is this case that I can regard to it as a landmark case, because it is this case whereby the court tried to give out or provide guidelines in regards to cohabitation. So the court came up with 8 guidelines on cohabitation matter, and these are guidelines of time. There must be a long period for that cohabitation to have existed. You cannot just be in a union or in a relationship for 2 weeks and then you go to court and say that you were in cohabiting and you want to like claim property and whatever, or you have to inherit like property. It cannot happen. The period must have been long and existed, and then there must not be another valid marriage apart from that one which you are claiming that you are cohabiting. So there must not be any other valid marriage apart from that one, and the burden of proof lies with that person who the burden lies on that person who is alleging. And we also have the standard of proof, and we also have the issue of age. The age must, those people must be of max of 18 years and above, because children cannot enter into a marriage relationship. Is prohibited and not legal as per the law. So in the case of MNK versus POM, this whereby people had cohabited for 25 years, and the wife was claiming that it was just friendship. It was just a friendship, but there was no valid marriage. It was just friendship. But we found that the 25 years is a long period, and just claiming that it's a friendship is not fair to the other party. So that's why the court adopted the guidelines to be followed. So so the court pointed out that cohabitation along with certain actors can be used to presume that a marriage. However, the presumption can be rebutted with a strong evidence in that case. So court established 8 guidelines, and this one is long cohabitation. The couple ought to stay together for a significant period, and the legal capacity to marry. Both parties ought to have attained the age of 18 and should not be in a subsisting marriage. Intention to marry. The evidence must express the intention to marry, and should be voluntary, not under duress or unwillingness. The consent must be there. The public reputation. This person must have been carrying themselves. They must have carried themselves as husband and wife, and the public must have presumed them to be husband and wife, presenting themselves as married couple to the community by way of their conduct. And the burden of proof. The party claiming marriage must bear the burden, and rebutting the presumption. Strong evidence can prove the presumption. So rebutting that presumption needs a strong evidence. So the standard of proof is on the balance of probability, but not on beyond reasonable doubt. So the court must be more likely than not to believe that the marriage existed. So in Hortensia Wanjiku Yawe versus public trustee, Hortensia Wanjiku Yawe, HOTTENSIA, Wanjiku Yawe, YAWEH versus public trustee. The court held that a long cohabitation was held to be 9 years. The parties were married to each other, and for 9 years with 4 issues. So issues here are children. So the court held that period, 9 years, was regarded as a long period, as a time for sufficient to prove that there was cohabitation, and the court was more likely than not to establish that truly there was cohabitation. So the burden here, the standard of proof is on the balance of probability, but not on beyond reasonable doubt. Just the court should be more likely than not to establish that there existed a marriage relationship. The court should be more likely than not to prove that there existed union. So the husband died in an accident, and the wife claims the estate, but family claims that they were not legally married and that she was not his wife. The evidence showed that she was recognized as a wife because they have cohabited, and also when he applied for a job, he named her as her wife, as his wife. So the two were requited as husband and wife. So in common law, so the case of R versus Peter, son of Mihayo, Mikhayo, we have the view that the holding in MK was the view that the view in MNK versus PO provides a comprehensive principle which ought to be referred in establishing its recognition. So therefore, it's a case scenario in which meets the threshold next in the holding of. So that is an important case, like a landmark case, the locus classicus.